will not be qualified to be a member of parliament if he owes allegiance to a country other than Ghana. The Supreme Court was recently invited to determine what this means, owing allegiance to a country other than Ghana. Is it the same as being a dual citizen? The Supreme Court's answer is the two cannot be separated. In Michael Ankoma Nemfa versus James Jachi Kwesing, the Electoral Commission of Ghana and the Attorney General. This afternoon, I have in the studio, live right here in Ghana, Professor S. Kweku Asare, KPMG Professor of Accounting, he's Professor of Accounting at the University of Florida. He's attorney at law, Florida Bar, CDD, Ghana Democracy and Development Fellow in Public Law. He's going to help us to discuss the Supreme Court's judgment on this question. Don't go anywhere. We'll be right back. This is The Law. It's your legal light. It's your health law. Of course, as always, you're welcome to join us with your questions at the end of the show. Prof, we are so privileged and we are thankful that you were able to make it to our studios.
Thank you so much, Samson, for having me. It's a pleasure to be here.
Great, great, great. And so you may be familiar with Professor Kweku Asare. He's a man some have labeled as a litigant at the Supreme Court. He's been litigating to help properly defined matters for our benefits collectively. Now, in this case that we have just referred to, the Supreme Court came to this conclusion, and I read. It said, this is at page 33 of the 35-page judgment. It says, we hold that by the requirements of Article 8, as amended by Act 527 and Article 94(2), I read that to you a while ago, A, any person who has obtained citizenship of another country other than Ghana and who files for nomination with the Electoral Commission to contest for election as a member of Parliament will not be qualified to contest for elections unless and until they show a record from the alternate state that they no longer hold the citizenship of that state, as at the date of filing their nomination with the Electoral Commission. Since the first defendant here, that is Jachi Kwesing, had not received his certificate of renunciation as a Canadian citizen as of the 9th of October 2020, then he was not qualified to be a member of Parliament at the time that he filed his nomination papers. At the time, he stood for elections, and at the time, he was declared as elected member of Parliament because he owed allegiance to another country as at 9th October 2020, the date when he should have satisfied the qualification criteria, and his election was declared null and void. It is the reason on Tuesday a by-election is being held in Asin North. Prof, you think the reasoning of the court was confusing and did not clearly do justice to the case? Help us appreciate.
Again, thank you, Samson. And I'm glad you are doing this because everyone would agree that when people have life tenure, they must be accountable for their decisions.
Right.
And in the case of the Supreme Court, their judgments are not subject to appeal. It can be reviewed, but it's different from an appeal. There's no right to review. And so the only way of ensuring decision accountability is forum like this, and in the classrooms, and of course, even Parliament sometimes can step in and say, well, we disagree with this, and go on and make an amendment to be sure that the law is being followed.
In one case that you did, it culminated in Parliament amending the law as far as our regulations for citizenship applications are concerned.
Precisely,
right.
Yes, yes. And it is also important to state that the Supreme Court has the final word, because litigation must terminate at some point in time.
That's right.
Having said that, that doesn't mean the Supreme Court is infallible. Now, in this case, I think interpreting Article 94(2)(a) is probably one of the most important assignments that the court could have undertaken. Because unknown to many people, a person who is not qualified to be a member of Parliament is also not qualified to be a member of the executive, is also not qualified to be a member of any of the constitutional commissions. So for instance, the Electoral Commission, the Land Commission, the Regional Land Commission, the NCC, and so on. And even more interesting, he's not qualified to be a founder, a leader, or an executive member of a political party. So per the ruling that the Supreme Court just gave, even in the diaspora branches, the executive members cannot be dual citizens, and therefore if there's any dual citizen currently holding executive position, then they are doing so illegally per the judgment that came about. And so with a decision with such ramifications, it's important that the analysis be exhaustive. Samson, it seems to me that the court's approach was as follows. Citizens owe allegiance to their countries. Therefore, whenever we see allegiance, as we are seeing in Article 94(2)(a), then it must be talking about citizenship. And if you assume that the only reason someone can owe allegiance is citizenship, then yes, what they are stating is correct. But that has nothing to do with the Constitution of Ghana. This is almost like somebody has written a statement, a person is not qualified to be an MP if he owes allegiance to a country other than Ghana, and then contextually starts to interpret it in the way that the Supreme Court has done, unfortunately. The starting point of understanding that they got it so wrong is to understand that Article 94(2)(a) predates dual citizenship. Dual citizenship was something that was allowed by Act 527 in 1996. On the other hand, the statement, a person owing allegiance in Article 94(2)(a) was always there in the 1992 Constitution, was in the 1979 Constitution, was in the 1969 Constitution, was in the 1957 Constitution. In fact, the 1960 Constitution is the only constitution that did not have that phrase, because obviously Nkrumah did not want anything that had even the vestiges of colonialism, so he didn't want even that word. So once you understand that, Article 94(2)A predates dual citizenship, then the whole decision that they gave crumbles. Because they are saying that dual citizenship cannot be decoupled from allegiance in Article 94(2)A. Well, so what did it mean when dual citizenship was not allowed? Was it just a meaningless phrase in the Constitution? So right there, you can see that they got it wrong. And I hope that people can understand the argument very easily. I've made the argument, I've simplified the argument that, look, if Article 94(2)A was there before we allowed dual citizenship, then it cannot reasonably be referring to dual citizens. That's point number one.
But you are not suggesting that the Article 94(2)A predating dual citizenship means that the provisions allowing dual citizenship, which was an amendment to the 1992 Constitution in 1996, is not part of the Constitution of Ghana, because that is how they looked at it.
Yeah, it's part of the Constitution of Ghana, but I'm suggesting that Article 94(2)A has a meaning independent of dual citizenship, because it was there before dual citizenship came. And we have to try and look for that meaning and not to confound it with dual citizenship.
Okay.
Number two, I'm going to suggest that if it was so simple as the Supreme Court has alleged, then the lawmaker would simply have said dual citizens, not a person who owe allegiance to a country other than Ghana. And so to go away from theory and to look at the Constitution, if you look at Article 8(2), Article 8(2) tells you that the framers of the Constitution actually knew how to refer to dual citizens. Not only that, they excluded dual citizens from holding certain specific positions under Article 8(2). So if you could read Article 8(2), I think it will be helpful for everyone.
Article 8(2) says, a person who becomes a citizen of Ghana by registration and immediately after the day on which he becomes a citizen of Ghana is also a citizen of some other country shall cease to be a citizen of Ghana unless he has renounced his citizenship of that other country, taking the oath of allegiance specified in the second schedule to this Constitution and made and registered such declaration of his intentions concerning residence as may be prescribed by law, or unless he has obtained an extension of time for taking those steps and the extended period has not expired.
Actually, that's interesting because you are reading the old Article 8(2).
Right.
I want the new Article 8(2),
which is the amendment.
Which is the amendment
allowing dual citizenship.
Precisely.
Right. So the old one, which allows dual citizenship.
No, the new one.
Yes, the new one, as in from 1996,
yes.
The amendment that occurred.
Yes.
It says, without prejudice to Article 84(2)A of the Constitution, no citizen of Ghana shall qualify to be appointed as a holder of any office specified in this clause if he holds the citizenship of any other country in addition to his citizenship of Ghana. A, Ambassador or High Commissioner. B, Secretary to the Cabinet. C, Chief of Defense Staff or any service chief. D, Inspector General of Police. E, Commissioner, Customs, Excise and Preventive Service. And F, Director of Immigration Service. And G, any office specified by an Act of Parliament.
Precisely. So what is this telling us? This is telling us that when the lawmaker, when the constitutional framer wanted to impose penalties on dual citizens, this is the way they frame it. They frame it in a way that leaves no doubt that they are talking about dual citizens. So in effect then, in the Constitution itself, there are two sources of disqualification. The first source is allegiance-based. And the second source, Article A2, is dual citizenship-based. Being a dual citizen is neither necessary nor sufficient to be allegiance ineligible under Article 94(2)A. That's the essence of saying without prejudice to Article 94(2)A. In other words, if you are a dual citizen, then inherently you owe allegiance to some country other than Ghana. And as a result of that, we are going to exclude you from holding those positions that you specified, ambassador, this and that. So that's the dual citizenship penalty. And any other office that Parliament would add.
Right.
So that's fine.
And as you stated earlier, by the Citizenship Act 2000, then additions were made. You cannot be Chief Justice, a Justice of the Supreme Court. You cannot be a Commissioner of the Value Added Tax, Director General of Prison Service, Chief Fire Officer, Chief Director of a Ministry, the rank of Colonel or its equivalent in the other security services and any other public office that the minister may by legislative instrument prescribe.
Precisely. So it's very clear. It should be very clear that the Constitution specifies two sources of disqualification. Being a dual citizen, you are disqualified from certain positions under Article A2. But a dual citizen who is disqualified from those positions under Article A2 will also be disqualified from being an MP if he owes allegiance to a country other than Ghana, as it means in Article 94(2)A, not because it's dual citizenship, because there's already an article in place for dual citizens. So that is the key problem that the court has. It took a constitution that has a separate Article 94(2)A and a separate Article A2, and it says, well, we don't like this guy, and therefore we are going to say Article A2 and Article 94(2)A are saying the same thing. Well, how can they be saying the same thing when the words are so different? And in interpretation, they tell us that there's something that is called the principle of meaningful variation. When the lawmaker changes terms, he doesn't do so just to change terms. He does so because he intends the term to mean something different. And that is the main problem. And Samson, the third problem that the court has in this judgment is they cite an Australian case. And when they cited the Australian case, they cited the Australian Constitution, Section 44(1). And Section 44(1), if the court read Section 44(1), it should have alerted them that allegiance to a country is very different from dual citizenship, because Section 44(1) in the Australian Constitution says a person is disqualified from holding office, whatever office is in Australia, if one, he acknowledges allegiance, obedience, or adherence to a foreign state. So that's one. Two, if he's a foreign subject or a foreign citizen. So that's dual citizen. And then three, if he enjoys the rights and privileges of a citizen of another country. So Section 44(1) makes it clear that allegiance to a country means, in constitutional law, something very different from a citizen of a country. And it also means something very different from enjoying the rights of a citizen. That Gallagher decision, if the court had advertised itself and read it slowly, would have made them realize that, hey, in the Commonwealth, because that language was inherited at independence by most of these Commonwealth countries, and they took the same form, and they had nothing to do with citizenship. So having shown that it has nothing to do with citizenship, I'm now ready to tell you what it actually deals with. And I don't do so from analysis. I do so by going to the legislative history, which is what the court should have done. Because when you go to the legislative history, specifically the memo accompanying the work of the Constituent Assembly of 1969, and if you read the Committee of Experts' work on 1992, they tell us that they borrowed liberally from the 1969 Constitution. So we know that they borrowed that phrase from the 1969 Constitution, and those framers explain that the allegiance article was put in place to disqualify people who are in occupations outside the country or even inside the country, but working for a foreign government that is incompatible with being an MP.
I'm coming to you to help us answer the question the court asked. How else do you determine that a person owes allegiance to a country other than Ghana? That is, a person owes allegiance to Ghana and another country. How else do you make that determination positively than by the fact that that person is a citizen of another country? But in the Australian case, which was both referred to by the plaintiff and the first defendant, the court made this reference that looking beyond Ghana, the plaintiff postulates that the facts of this instant case, that is James Jachis Kweson's case on Article 94 2A, said the facts of this case are akin to the Australian case of Ray Gallagher, 2018, HCA 17. In that case, an Australian senator who had attempted to renounce her foreign, that is British citizenship, prior to her nomination, but whose application had not been processed by the British authorities until after her election, was disqualified by the High Court of Australia. The relevant provision in question was Section 44I of the Australian Constitution. And you said if they had read this slowly, they would have come to a conclusion which is contrary to this.
Yes.
This is what that provision says. Any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject.
Slow down. Go back.
So it says
where you say or, highlight that.
Okay. Obedience or adherence to a foreign power, comma, or is a subject or a citizen. All these places, there's no comma. After foreign power, there's a comma before or. Is a subject or a citizen or entitled to the rights or privileges of a subject or a citizen of a foreign power shall be incapable of being chosen or sitting as a senator or a member of the House of Representatives.
Yeah. Now, that Australian Constitution, that article that you read, has 3 wings.
Okay.
The wing number 1 is a person who has acknowledged allegiance, adherence, or obedience to a foreign power. That is our version of Article 94 2A. Then there's a big or. That or is telling you that now we are going to talk about something else. The second thing that they talk about is a citizen or a subject of a foreign country. That is our Article 8.2. And then they even have a third wing, which we don't have at all, somebody who enjoys the rights and privilege of a foreign country. So for instance, in the UK, you don't have to be a citizen of UK to be elected as an MP. If you are an Australian and you are elected as an MP or you vote, I mean, all of those things are rights and privileges of a foreign country, then the third wing will get you. So if you just take the Australian Constitution and you read it anyhow, then you are going to get it completely wrong, because in the Gallagher case that they cited, it was dealing with the second wing, the dual citizenship wing. It wasn't dealing with the allegiance wing at all.
The court said that the High Court of Australia took the view that the duties of the allegiance owed by a person who holds foreign citizenship remain engaged until the foreign state in question has confirmed and registered that person's divestment of citizenship and thus of allegiance.
Yeah, that is at our Article 8.2. So the person was being disqualified because he was a dual citizen, not because he owes allegiance to a country other than Australia. Unless that distinction can be understood, then we cannot make progress, and we're going to be stuck in the same place that the court is stuck. Because in Australia, when you read the Australian literature, which I'm very, very familiar with because I've invested time to read it, it is clear that they distinguish allegiance from dual citizenship. And some of the case law on allegiance in Australia test whether somebody who is, for instance, a honorary consul. So let's say you are an Australian, but you are a honorary consul for Ghana, handling Ghana's consulate affairs in Australia. They test whether if you occupy such a position, will you be disqualified under the allegiance wing? And they've even tested whether people who are Roman Catholics will be disqualified because they owe allegiance to the papacy. And they've tested whether somebody who demonstrates against a friendly war vessel, so the allegiance wing, which we retained in Article 94(2)(a), is different from the dual citizenship wing. They were citing the wrong case. It was the same thing like citing Asari. They cited Asari.
Yes.
Well, Asari has nothing to do with...
You did that case, and they say in that case, the court inferentially came to the conclusion that you cannot determine the question of allegiance without the question of citizenship.
That's missing the point, because let me be clear. A citizen owes allegiance.
Correct.
And that is why in Article 8.2, there are certain positions that a dual citizen cannot hold.
All right.
Independent of the citizen holding allegiance, there's Article 94(2)(a), which is talking about allegiance.
And this same Article 8 says, without prejudice to the Article 94(2)(a). Precisely.
Instead of in addition, so if, for instance, dual citizen and allegiance are the same, they are not the same because the words are different. But if they were talking about the same thing, they would say, in addition to the positions that dual citizens are disqualified under Article 94(2)(a), which will not make sense because dual citizens were not even allowed when Article 94(2)(a) was there, then they cannot hold these other positions. Rather, they are saying without prejudice, and that without prejudice means, number one, as a dual citizen, just because you owe allegiance to a foreign country, these positions are out of bounds to you. But you can also be disqualified from being an MP and other positions under Article 94(2)(a) if you engage in an occupation that is incompatible with being an MP. That is what Article 94(2)(a) means. Article 94(2)(a) will kick in, for instance, if you had a citizen of Ghana who is not a dual citizen, it could be a dual citizen, but a citizen of Ghana who serves in a foreign military. So let's use the example of the United States. You don't have to be a U.S. citizen to serve in the military of the U.S.
We have Ghanaians who are in there.
You have Ghanaians who are residents and they are in the military. They will swear allegiance, and that is something that Article 94(2)(a) is addressing. If you go to UK, they don't have any of this in their constitution, but they have what they call Parliamentary Disqualification Act. And one of the grounds for which you can be disqualified is if you are a legislator of another country.
Okay.
So they deem that being a legislator of another country is incompatible with being a legislator of UK. So Article 94(2)(a) is occupation related, not because I say so, because if you go to the 1969 memorandum accompanying the work of the Constituent Assembly, the first thing they do is they say a Ghanaian who is a citizen of another country automatically will lose his Ghanaian citizenship. Then second, they say a Ghanaian who owes allegiance to a country other than Ghana cannot be an MP. And they explain that the reason for this is because there are some occupations that are incompatible with being an MP. So the big thing is to understand that allegiance is not only citizenship based. If you assume that allegiance is only citizenship based, then the distinction that you can see in the Constitution, because after all, in the Constitution, there's an Article 94(2)(a) and there's an Article 8(2). If allegiance to a country other than Ghana is the same as dual citizenship, why do we have allegiance under Article 94(2)(a) and dual citizenship under Article 8(2)? That would make no sense, but it makes sense. It's just that it's not being properly interpreted. And that's what I've demonstrated to you with the Gallagher case.
But in the Gallagher case, again, the provision in question begins by saying if that person is under any acknowledgement of allegiance.
Yes.
Under any acknowledgement of allegiance.
Yes.
A Ghanaian, before you become a citizen of Canada, you will take the oath.
Of course.
And in the oath, you will swear allegiance to the state.
Yes.
So when you do that, what is that? What is the effect of that? The Supreme Court asked that question.
Well, that's not a good question. That's not an interesting question, because the Australian thing that you just read not only says allegiance, and then it says or dual citizenship. Well, that is telling you that dual citizenship is different from the allegiance. There are three wings. So to just confuse the two and tautologically keep saying it doesn't make it right, because it is clear from the Australian thing that the three things are in the disjunctive. You can be disqualified if you owe allegiance to a country other than Australia, or even if you don't owe allegiance to a country other than Australia, you can disqualify because you are a dual citizen, or you can be disqualified because you enjoy the rights of a foreign citizen. So that when the Gallagher case was not based on the allegiance wing, it was based on the dual citizenship wing. So if it was Ghana, the Gallagher case would have been brought under Article 8(2), not under Article 94(2)(a).
What you are saying is contrary to what the Attorney General was urging on the court and the plaintiff. The Attorney General, the court says, regarding the concept of allegiance, the Attorney General submitted that allegiance must be construed objectively in terms of Ghana law and not subjectively. You want it construed subjectively.
No.
And he says, and that a proper interpretation of the laws of Ghana will lead to the conclusion that allegiance means the exclusive holding of Ghanaian citizenship.
No.
So if you are Ghanaian and you hold another citizenship, in the view of the Attorney General, in the view of the plaintiff, and which the Supreme Court endorses, you owe allegiance to a country other than Ghana.
Yes. Let's accept that. And I've explained many times that that's why under Article 8(2), a dual citizen is disqualified from holding these offices. So there's a penalty for being a dual citizen, and the reason there's that penalty is because you owe allegiance to another country.
Right.
that is not the meaning of Article 94.2a. Article 94.2a means something different from citizenship-based allegiance. And that is a concept that is very easy, but I mean, you have to think through because, and that's why I sent you that chart to show you that there are many reasons why somebody can owe allegiance. So for instance, in some countries, even if you are a judge, you are supposed to take an oath of allegiance. So somebody like Justice Doche, who is a member of the panel, he was a Supreme Court Justice of Gambia. I don't know what the rules are in Gambia, but if the rules are similar to what I'm thinking about, he would have been made to take the oath of allegiance because he's a judge. Somebody who serves in the foreign military will be made to take an oath of allegiance because of that foreign thing. And I've explained that in Ghana, we even had an interesting case in 1985. I'll come to this. In 1985, where Susudis, a Ghanaian, who was extracting information from a CIA lady, was swapped for some mono Ghanaians, not dual citizens, but the US media described those mono Ghanaians as CIA assets. They were so important to the CIA. Why?
Even though they didn't have dual citizenship?
They were mono citizens.
Okay.
But they were working for the CIA, passing on information about Ghana to the CIA. That is the type of allegiance that Article 94.2a is describing, and it is easy to understand because Article 94.2a existed even when we didn't have dual citizens. And so to now say that the only meaning of Article 94.2a is that it applies to dual citizens is, well, what did it mean when there were dual citizenship?
So once again, this question, and it is critical because it is the anchor of the decision. The Attorney General said, the most objective way of ascertaining whether a person owes allegiance to a country other than Ghana is by establishing whether that person holds the citizenship of another country. The issue of allegiance cannot be verified or ascertained through any form of subjective means, as this would be unreasonable and absurd. How else can you verify that someone owes allegiance to another country, to a country other than Ghana?
Well, it's not a very interesting statement because it's once again assuming that the only way you can owe allegiance is to be a citizen, and then it introduces this weird concept that law schools should be shut down because the only thing that we can do is to verify objective things. So murder should be removed, and then we only deal with manslaughter because murder requires us to evaluate the mens rea of the perpetrator. Merely because something is difficult to do doesn't mean it shouldn't be done. It's almost like the street light, some kind of street light jurisprudence, where somebody comes to Kokomlemle on the north side and loses money there, and he goes to the south side to look for the money, and you ask him why. He says, well, it's easier to look at the south side because there are lights there.
So what do you say in plain words will be your approach, other than using the fact that you are a citizen of another country as the proof that you owe allegiance to that other country in addition to Ghana? How else can we prove it, that you owe allegiance to a country other than Ghana?
Let's use Canada. Okay, in Canada, there is a case. The name of the case is Makatia. The court does not cite it. And in that case, the courts said that citizenship and allegiance can be decoupled because there were people who were saying to become citizens, they had to swear the oath of allegiance, and they didn't want to swear the oath of allegiance to the king or to the queen of England. And the court said, look, allegiance or swearing this oath is a ritual. You just go through, get your citizenship, and once you get your citizenship, you can disavow allegiance. So there's a website called disavowal.ca. And if you go there, you see a whole bunch of Canadians saying they've disavowed their allegiance. That is the easiest example of a country that decouples allegiance and citizenship. So you can be a citizen, but they correctly reason that allegiance is a mental thing and nobody can urge you to it's there, but it doesn't mean anything, and you can disavow it. But let me show that screen, because that is critical.
Yes. Right.
If you look at that screen, I have allegiance, and then I show that on the allegiance, it can be either citizenship-based or non-citizenship-based. So there are two ways that a person can owe allegiance to a country: citizenship and non-citizenship. And you can see I show that under citizenship, there's natural allegiance. So if you are born a Ghanaian, you naturally owe allegiance. You don't have to do anything. And then there's acquired allegiance. These are people who naturalize or register. They have to take an oath of allegiance. And that is basically the citizenship-based allegiance. Article 94(2)A is not talking about that, because Article 8(2) is the one that addresses a person who has multiple citizens.
Okay.
Then you go to the other wing, which is non-citizenship-based allegiance. First, they are residents. So let's say people who are permanent residents of Ghana. They are not citizens, but they still owe allegiance to the country because they have to follow our law and we have to protect them. That is called local allegiance. That's residence-based. And then there's employment and other activities. So you can just go and do some job, and then they ask you, like foreign military. In Maryland, for instance, if you're an attorney, you have to swear an oath of allegiance. So those are employment and other activities. And under the employment and other activities, the employment can be routine. You go and you work, and that's not what Article 94(2) is targeting. Article 94(2) is targeting jobs that are incompatible, inimical, or prejudicial to Ghana's interests. That is Article 94(2)A. So all these things about we can't separate allegiance and citizenship, which is all interesting, is dealing with the citizenship wing. But Article 94(2)A is not dealing with the citizenship wing. We know that. How do we know that? We know that because dual citizenship was allowed in 1996. And it cannot be the case that Article 94(2)A had no meaning until dual citizenship came into effect in 1996.
If you are just joining us, we are having a discussion of the Supreme Court's decision in Nemfa versus Jachikwe Singh, the Electoral Commission, and the Attorney General. And our guest helping us with that discussion is Professor S. Kweku Asare, who is KPMG Professor of Accounting at University of Florida. He's attorney at law, Florida Bar, CDD Ghana Democracy and Development Fellow in Public Law and Justice. So we have very limited time, about less than some 15 minutes. Share your views with us. I think what I'll do is that I'll open the phone line just about 5 minutes, then you share your views. But you can also put them on social media where you have seen that we have posted the flyer and so on, and we'll share them with Prof. And first of all, there's one question that is going back to the question of the oath of allegiance. How can you fault the Supreme Court in that? So, sitting here with you, by the explanations you have given and by using the chart you have, I may not have to ask you this question again, but this show is for our viewers. It says, is Prof saying that the swearing of the oath when acquiring another citizenship like Canada or the US has no material effect in dealing with the question of allegiance?
It does. And that's why I've explained that we have Article 8(2). Article 8(2) doesn't use the word allegiance because once it says you are a citizen of another country, we are disqualifying you from holding these other positions. It's inherent in being a citizen of another country that you owe allegiance to that other country. So Article 8(2) is clear that dual citizens are going to be excluded from some other positions. Then the bigger question is, because we've seen allegiance in Article 94(2)A, does it mean we should just assume Article 94(2)A is the same as Article 8(2)? And that's just not law. If you did that, you are not doing law. That at that point becomes just emotions.
Does Article 8(2) disqualify you from being a dual citizen?
No, it doesn't.
It doesn't.
It disqualifies you from holding certain positions because you are a dual citizen.
I mean, does it disqualify you from being an MP?
No.
Because you hold dual citizenship?
No, it doesn't.
It doesn't?
It doesn't, yes.
But Article 94(2)(a) disqualifies you from being an MP because you hold allegiance to another country other than Ghana.
Yes. And that allegiance to another country other than Ghana is a term of art. It is not citizen. Otherwise, I've demonstrated that when the lawmaker wants to say citizen of another country, they know how to say it. So if they have not said a citizen of another country, just forcing allegiance to another country to be citizen of another country is just emotional law. It's not law as we are taught, and it's not law as it should be practiced. And I've given several cases.
Your position, you fortify your position by the fact also that you can owe allegiance and not be a citizen.
Yes, absolutely.
Because there are non-citizen based allegiance.
Yes, absolutely, absolutely. And the biggest and the easiest way to understand this argument is that Article 94(2)(a) was there when we didn't even have dual citizens. So what did it mean when we didn't have dual citizens? Did it have no meaning?
Okay.
I mean, the Supreme Court is saying it was meaningless when we didn't have dual citizens, but that cannot be correct because that clause has been in the 1969 Constitution, has been in the 1979 Constitution, and both the 1969 and the 1979 Constitution did not allow dual citizenship.
All right. Prince, you are calling us from Legon, East Legon. Prince, straight to your question. We've lost Prince. Prince, you can call again and you will have the opportunity to ask that question. The court was so clear that it says that the court in the matter that you brought before them in Asari versus Attorney General in 2012, the court assumed the words to mean being a citizen of a country other than Ghana. Citizenship and allegiance are bound up in the same spirit. So I'm practically asking you a question you have answered.
Yes, because when I took my case to the Supreme Court, if they read it, it was under Article 8(2). I was saying that Parliament could not, one, just say they can add positions. We have to amend the Constitution each time we want to add positions. And two, there was another one which says the minister can add positions. And I said, well, no, the minister cannot add positions. It has to be done by a constitutional amendment. And that is the basis of my lawsuit. My lawsuit had nothing to do with allegiance to a country other than Ghana, as used in Article 94(2)(a).
Well, they said this was inferentially, clarified. And they said that this court was very clear that citizenship was bound up with loyalty to the state and allegiance to it. And they seem to say the two cannot be divorced.
Yeah.
Yes, let's get to... hello, Richard.
Hello, Samson.
Yes, go ahead with your question.
Yes, my question is to Professor, and I want to know really that if there is no distinction between dual citizenship and allegiance, can the professor really explain that to me? Because I'm getting confused with it.
He's done that. He's done the differentiation. He's done the differentiation already.
Okay.
Who is our next caller? But I'll make him try and get back to it again. What do you say to Richard?
Well, Richard, look at Article 94(2)(a) and look at Article 8(2). They are different articles, and they are talking about different things.
Says they are different, and they are talking about different things. They had to an important matter. I don't know whether you disagree with what the court thought about this, but because of your position, then it means this question too is a difficult one to ask you. They say that the member of parliament whose election they declared as null and void filed his nominations in October. Now, in October, he had not received the certificate of renunciation. They used the Australian case, and they said in that case too, because the person has not received the renunciation certificate, it was important. So even though the elections, the proper process was in November, if you say that, we shouldn't say he's disqualified from when he filed his nominations. Then, when the renunciation certificate came, it was effective November, not October. So why do you want us to stretch it back there?
Well, I mean, again, you prefaced the question correctly, because I don't agree with that whole thing. But let's play along, and then let's say, instead of citing the Australian case, the court should have actually looked at our statutes, because we have representation of people's law that determine these dates. And if you look at PNDC Law 284, Section 9.1, Section 9.2, and Section 21D, they exhaustively deal with this matter. In fact, Section 9.1 says that being a Ghanaian, being 21, and paying your taxes, those are eligibility requirements, and those are determined when you file your nominations. The wording is a candidate for the election of an office. Then they go to Section 9.2. Section 9.2 doesn't talk about the candidate. It talks about qualified to be an MP. In other words, anybody at all can be disqualified from being an MP at any time. So even today, if we find out that an MP, is owing allegiance to a country other than Ghana, or is bankrupt, or is convicted of treason, all of those things in Article 94 too, then he will be disqualified.
Frimpong, you are calling us from Ejusu. Let's hear you.
Yeah, I want to ask Prof. Where was he when Supreme Court passed judgment on Adamu Sakandi?
I was there helping Adamu Sakandi defend himself. Adamu Sakandi is a friend of mine.
And he was jailed, isn't it?
Yeah, he was jailed, and I have written so many things that said that was a travesty of justice, and I don't want to see another travesty of justice.
All right. Okay. Hold on. Fred. Okay. Please take Fred off. We are not going to have a banter. And there are people who also confuse Adamu Sakande with this case. In this case, the matter was that by the time he was filing, he had filed his renunciation, but he didn't get the certificate of renunciation. In Adamu Sakande's matter, there is a certain complete difference, because his thing was not whether he had renounced or he has not renounced. Okay? Adamu Sakande was found to have, I think, 3 different passports. In this case, he says, I had 1 additional from Canada, but I have renounced it. So let's not bunch the two together. They are not exactly the same. But on the question of dual citizenship as against allegiance, citizenship as against allegiance, that's the focus of the discussion by Prof. Thank you very much. Now, so they said, for example, that Zanato Rawlings matter. They had declared in that case that the time when you file is when we should begin to consider whether you are qualified or you are not. So for the argument being made that the time when he was elected, he had already received his renunciation certificate, so he should be deemed to have been properly elected because he didn't owe allegiance then. He was not a citizen of Canada then, should not hold. What do you think about that one too?
Because Zaneto was under Article 94.1, and Article 94.1 is an eligibility criteria. If you are not a Ghanaian, if you are not 21, then you are not eligible. And that is determined going to Section 9.1 of the PNDC Law 284 when you file your nominations.
Okay.
This case is not about eligibility. This case is about disqualification. This case is about who can sit in Parliament. And it says if you owe allegiance, you cannot sit in Parliament. So it can be determined much later. In fact, as I said, even currently, people can be disqualified if they are found to owe allegiance. So that is always ongoing.
So it is also your view that Adamu Sakande, even though he was holding dual nationality, not like Jachi Kwesing, who was clear he had renounced it, he still should not have suffered.
Yes, that's basically my support for.
Because your point is that dual citizenship does not disqualify you.
Precisely.
Okay.
It disqualifies you from certain things.
But not being MP.
Yes.
Okay, our very final caller. Hello, sir.
Yeah, hello.
Yes, go ahead with your question.
Yes. My question has to do with the difference between allegiance and loyalty. Because if you look at the Supreme Court ruling, it seeks to, juxtapose the ruling towards the side of royalty. So I want to know the difference between royalty and then that of allegiance.
Right. Thank you very much. So if you have been listening to Prof, you can reiterate the point. As far as the Supreme Court is concerned, loyalty, allegiance, that's what it is. And that's what it means to be a mono-citizen and a good one. So once you have allegiance to another country, it means loyalty is lost to Ghana.
Yeah, and that is, again, problematic, because if you accept that, then Article 94(2)(a) is meaningless unless you have dual citizens.
Right. So we understand that there's an attempt to go for a review over this. You have the hope that a review can change matters?
Yes, I think if you have a panel that actually wants to sit down and listen rather than just come out and say citizenship is allegiance, therefore, no, citizens owe allegiance. But that's why we have Article 8(2). We have Article 94(2)(a). It means something, and they should look in the 1969 Constituent Assembly. They explain that. And so if they do a thorough job, they would be able to reverse themselves and say, look, we have it wrong.
Interesting. We have been having a discussion of the Supreme Court judgment on Judge Ikwesing, the judgment that annulled his election, with Professor Kweku Asari. He's KPMG Professor of Accounting at the University of Florida, Attorney at Law, Florida Bar, CDD Ghana Democracy and Development Fellow in Public Law and Justice. This has been The Law. It's your legal light. It's your help law. I'm Samson Lardy Anyenini. We'll come your way again next week with an interesting edition. Have a good afternoon. Prof, once again, thank you very much for making time to join us.